My name is Bartłomiej Oręziak and I'm a member of the Central European Professors Network 2021. Exactly in the group, the impact of digital platforms and social media on freedom of expression and pluralism, headed by Professor Marcin Wielec. This research project is conducted by the Filmspeler Institute of Comparative Law in Budapest. I'm also a PhD student at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. And now, however, going to the topic, I will allow myself a preliminary consideration. I will talk today about the genesis of linking limitation on the internet, what was born in the Court of Justice of the European Union, hereinafter Just Card. So my speech will focus on the judgment in GS Media as the most important and revolutionary case in which the court introduced the first explicit linking restrictions. It was issued after the judgment in Svensson and Bestwater, in which the court, in my opinion, as a rule, did not introduce a restriction on the freedom of linking on the internet. At the end of my short speech, I will also sign out the cards realize the two next judgments, the Filmspeler and the Pirate Bay judgments. So, ladies and gentlemen, going to the facts because it is not meaningless. But very briefly, in October 2011, the publisher of some famous magazine, Sanoma, took photos of Mrs. Decker in order to use them in December 2011. They wanted to publish them in their magazine, but in December. However, at the end of October, HiStyle website, this is a website with latest news in Netherlands, owned by company GS Media, got a message from anonymous user with a hyperlink reference to a website where there was a file with pictures Mrs. Decker and hereinafter just disputed photos for Simplify. In fact, placing a photo on the internet was illegal. Okay, but what about linking or sharing them? Of course, for a long wait, it did not have to be, because on the same day on HiStyle appeared an article containing a hyperlink to the disputed photos. It was October. After Sanoma's protest, GeneStyle website editors decided to publish a second article on the dispute which arose between them and Sanoma. And this article has added a hyperlink to the ImageShake US website where there was disputed photos. Finally, HiStyle published the third and the last article, which again contain a hyperlink reference to the disputed photos, under which internet users put in the form of comments following hyperlinks reference to the various websites with disputed photos. According to Sanoma's plan, the photos were published in December in magazine. But the fact also is that in the internet, the disputed photos was available already in October in the internet, and HiStyle made linking this photo against Sanoma. As may be expected, on the one hand, Sanoma, Mrs. Brit Gertrude Decker and GS Media on the other hand have fallen into a court case brought before Supreme Court of the Netherlands. Judicial arguments has focused on the interpretation of the concept of communication to the public used in Article 3, Paragraph 1 of Directive 2001/29, and now also for simplify speech, hereinafter just a directive. This court, having doubts as to the substance of the case, decided to stay proceeding and under Article 267 of the Treaty of Functioning of the European Union ask free question for a preliminary ruling from the Court of Justice of the European Union, and this court indeed sought to establish, in fact, in essence, whatever and in what possible circumstances the fact of posting on a website a hyperlink to protected works freely available on another website without the consent of the copyright holder constitute a communication to the public within the meaning of Article 3, paragraph 1 of Directive 2001 on 29. In fact, this question was a question about legal liability of GS media linking, sharing disputed photos, because this body, these entities not upload directly to the internet these photos. They only, or not maybe only, linking them and sharing them to the internet users as a whole. Ladies and gentlemen, the substance of the ruling in the GS media is to point out how the concept of communication to the public used in the directive should be understood. The composition of the court proposed to look at them through the prism of the principles and factors indicated in the judgment. This refers to the principle of two conditions and the principle of individual assessment. The first one consists in the fact that the term communication to the public combines two premises that require simultaneous fulfillment. This is the act of communication of the work and sharing it public, while the second one requires a personalized assessment, which can be made after taking into account many complementary factors. The first factor identified by the court is the essential rule of the user and the intended nature of his action. He performs the act of communication when he is fully aware that if it were not for his operation, other internet users would not, of course as a rule, have access to the protected work. The second factor is the very concept of public, which assumes unlimited and at the same time quite a large number of potential audience. However, it should be borne in mind that the use of the term communication to the public requires that a protected work be made available through a different technology than that which was previously used. In case of technology identities, for example, internet to internet, we are forced to refer to the concept of new public. So to make a protected work more accessible to a wider audience than it did before. The third factor is the consent of the copyright holder, as the court pointed out on its earlier ruling. If the consent is of an unrestricted nature, then it is to be accepted that such consent includes all internet users as such. On the other hand, when it is limited in scope, we must appeal to the already mentioned new public term. Citing the judgment, accordingly, it cannot be inferred either from the judgments of Svensson and others, or from the order of Bestwater International, that posting on a website hyperlink to protected works which have been made freely available on another website, but without the consent of the copyright holders of those works, would be excluded as a matter of principle from the concept of communication to the public within the meaning of Article 3, Paragraph 1 of Directive 2001/29. Rather, those decisions confirm that the importance of such concerns under that provision, as the letter specifically provides that every act of communication of work to the public is to be authorized by the copyright holder. Ladies and gentlemen, the fourth, last but maybe not least factor indicated by the card is the profit nature of the communication to the public. It is therefore important that the user publication publicate protected work to increase their access. It will be, of course, some kind of professionals, or it is the opposite and does it without profit, and this is, of course, some kind of non-professionals. This is a key distinction because in the first case there is a presumption that the user knows or could responsibly have known that the protected work was published without the permission of the copyright holder. In contrast, in the second case, there is a presumption, of course, of opposing content in relation to both. Also, of course, there is the possibility of proving the contrary. Ladies and gentlemen, in the light of above, the card concludes that Article 3 of Directive should be, or maybe not, maybe must be interpreted as meaning that in order to establish whatever the fact of posting on a website hyperlinks to protected works which are freely available on another website without the consent of the copyright holder constitutes a communication to the public within the meaning of this provision. It is to be determined whether those links are provided without the pursuit of financial gain. Yes, this is this factor of profit nature by a person who did not know. This is very important. Not know or could not responsibly have known the illegal nature of the publication of those works on that other website or whatever. On the contrary, those links are provided for such purpose, a situation in which that knowledge must be presumed. Knowledge must be presumed, so the legal liability appear here in this situation. Dear ladies and gentlemen, now very briefly going to the Filmspeler and the pirated by cases. Only in the form of signaling I will say that these judgments prove that the principles and factors developed in the GS Media judgment are consistently applied by the card, because it was on their basis the card come to a conclusion on Filmspeler that the concept of communication to the public within the meaning of Article 3, Paragraph 1 of this directive must be interpreted as covering the sale of a multimedia player on which there are pre-installed add-ons available on the internet containing hyperlinks to websites, of course, that are freely accessible to the public, on which copyright protected works have been made available to the public without the consent of the right holders. It seems to me, in my opinion, it is a new kind of linking as determined by the card, maybe linking physical devices, linking outside the internet, which results in a factual measure that is expanding the circle of entities responsible for linking, for hyperlinking, for sharing. Also, on the basis of these principles and factors, the court comes to a conclusion on the pirate by case that the concept of communication to the public from Article 3, Paragraph 1 of Directive must be interpreted as the making available and management on the internet of a sharing platform which by means of indexation of metadata relating to protected works and provision of a search engine allows users of the platform to locate those works and to share them in the context of a peer-to-peer network. What can lead to the conclusion? Maybe in future that giving like it on Facebook will also subject to the restriction in question. I would like now to summarize my speech, my dissemination speech. I would like to point out that the judicial process does not change in these judgments. It is based on the same factors and principle as in the case of GS Media, and in another cases also it is the same. And in this should and that it should rise maybe no doubts. This is not considerable. But the inference process does not change, yes. But the product of this inference, of this logical, legal inference, change. And finally, I would like to share with you my reflection on a EU Court of Justice model of inference and to present selected problems, only selected problems relating to this. The first problem is a problem of copyright holders' consent. In my opinion, it is impossible to determine, even with due diligence, that all protected works with professional entity has made available have been placed on the internet with the consent of the copyright holder. The consequence of this uncertainty is action of presumption according to which this person or entity knows or could responsibly have known the legal nature of the publication of protected works. The second problem is the problem of subjective assessment. Ladies and gentlemen, a subjective factor can be very difficult to interpret by the national judiciary because this is a study of the attitude of the perpetrator, yes? It seems to be a responsible question. How to interpret this subjective factor in the light of objective copyright infringement in accordance with its general principles? Maybe in future we will thinking about this, but now this is the problem. And the third problem is a problem of profit of a profit factor. In my opinion, profit factor is somewhat pointless. This is because, as a rule, the copyright holder is not interested in whatever his rights were violated for profit or not. If the court actually wants to effectively protect its rights, it should apply another more useful factor. For example, liability based on the rules of the Directive 2000/31. This is some idea, of course. And next problem of hiding. The system of responsibility proposed by CART makes it impossible for EU law to classify the disturbed behavior as hiding. As we know from the Svensson judgment, Directive 2001/29 is exhaustive. This means that hiding is an excessive extension of protection from this directive. In the future consequence, this is a serious problem with the implementation of the judgment in the countries that provide aiding. And next problem of potential inconsistencies among member states. Considering all these problems, we are seeing another one. Courts in different member states may apply the principle and factors proposed by the court in various ways. I think it will be. This may lead, instead of harmonization, to disharmonization of the rules of the information society. And last but not least, problem of freedom of expression. These kind of interpretations are area where it is easy to violate the freedom of expression. You have to be very careful in these regards. I do not say that in the judgments presented by me in this speech such violations takes place. However, I say that these judgments are the foundation from which arguments in a different court cases grave where there may be justified doubts in compliance with the freedom of expression. This is about genesis of linking restriction of the internet in GS media. And now I refer to another one case. It is a Renckhoff case. This matter is broadly described by me, and it will be published by the Ferenc Magul Institute of Comparative Law under the Central European Professors Network 2021. And now, this short reflection, I would like to end my speech and thank you very much. Thank you very much.